Welcome to Work This Way, a labor and employment podcast. I'm Tina Emerson, alongside Maynard Nexon attorney Jennie Cluverius. Good to see you, Jennie.
Good to see you, Tina. Thank you for having me.
Of course. Today we are continuing our discussion with Drew Rogers, Senior Federal Mediator of the Equal Employment Opportunity Commission, or the EEOC. Drew, thanks for sticking around with us.
Hey, pleasure.
Of course. And now in part one, we discussed the charge filing process and classifications of charges and mediation confidentiality. Today, we're going to delve a little further into the actual mediation process itself. So let's begin with you telling us what you expect from the parties in advance of a mediation in order to make it successful.
Sure. Well, some of these are like my own trade secrets, like my own little
Well, let us hear them.
I know. I'm afraid to give them away. Helps my success. So one thing that I really, and this is really more for both parties are represented, not maybe a pro se charging party. But when both parties are represented, I ask, more than anything, I'm very clear that I expect that the plaintiff's attorney will make an opening demand, and that the company or the legal representative will make a counteroffer prior to coming in, and they'll have a conversation just to make sure that the ball is kind of moving forward, and that not only kind of propels the mediation into a positive, movement, but also it helps with making it more expeditious and making sure that people are coming with truly a good faith mediation, because it can be that either side, maybe there's limitations on what can actually be resolved in terms of on the company side, resolution options, or maybe the plaintiff side is just kind of really out there and there's just no simple way to resolve it. Maybe the expectations are just too high. But if there's just some simple conversation beforehand, things can really get going. So that's one thing that I just simply expect, and I ask that people do. And that's really the only thing I need. Some other people that I know, and if you ask 10 different mediators, you're going to get 10 different answers on this. But I don't require like a mediator brief or anything like that, because I have very high expectations myself. So I feel like, hey, I'm always optimistic. We're going to get this resolved. So as long as everybody comes to the table in good faith, there's no reason we can't get it resolved.
So you mentioned pro se parties briefly. In the event an employer is going to mediate a matter through the EEOC and there is a pro se or unrepresented party who has filed a charge, they aren't represented by legal counsel, is there anything in particular that you would advise those parties to do differently to prepare to try to have a successful mediation with a pro se individual?
For the company.
For the company.
Yeah, I think it's always better to come more prepared. In other words, bring more to the table and keep an open mind, because pro se parties always have an expectation that their case is essentially bulletproof. And it's my job to always stay neutral, but also help them understand how, what their rights are, give them a risk analysis, and the same for the company, and then help that ball keep moving forward. Another thing is I get a lot of requests to get opening, what does the charging party want? Get opening demands. And just as a matter, of rule, for me, I don't do that in advance, because I don't have any rapport and I don't have time necessarily to have those long conversations with them prior, other than the scheduling call. And I always like to be hands-on in terms of the scheduling call with them, and then send out the scheduling emails to both parties. But just as a matter of rule, for me, I don't do that, because I don't have time to build that rapport. So I need to explain to them how damage calculations work, things like that. And I do that the day of the mediation, because I haven't heard from both sides. Because again, I think in the last podcast we talked about the position statement gets put on hold. So I don't have the side from the defense. I don't know what their view is. So just come more prepared, and if If it ends up being less of an outcome, great, whatever. As long as everyone is happy with the resolution, that's my job, is to help get everyone at the finish line.
Well, your comments there are a good segue into what I wanted to ask you about next. You're talking about building rapport with the parties in the room and trust as the mediator. I realized the EEOC during the pandemic was conducting a lot of mediations remotely or electronically. I wanted to ask you about whether the EEOC is still doing mediations electronically, whether they're doing mediations in person. Can you talk to us a little bit about the agency's position on that right now?
Sure. The agency's position is that we do both. So as long as it's pretty much everyone's on board, we can offer the in-person, as long as we have the operating space to do that. It's not always available in terms of the operating space, but I think companies still have kind of we like the virtual side, because for instance, a company maybe the representative in terms of the company maybe say in LA or something like that, but the attorney may be in Columbia right here, or Greenville or whatever. Well, they may not want to fly and spend that money from LA or whatever. But if, say, we had two attorneys or everybody was there in Greenville, well, that's not hard to do face-to-face, and we can do it right there in Greenville. It's not a problem. Or a pro se person may live in, say, another area in maybe Asheville or Rock Hill or something. They may not want to drive in. So we have to operate within the boundaries that exist, especially since people have gotten used to using Zoom and things like that. So,
what would you tell an employer or a charging party who is concerned that conducting a mediation electronically via Zoom or similar type of medium is going to cause it to be less effective than if the mediation was conducted in person?
Well, I think this kind of goes back to another question we asked in previous episodes, so make sure you watch the previous episode. But the average settlement, or rather the average success rate, is really great, I think, just across the board for the U.S. Mine tends to run a little bit higher, but I have found that the Zoom mediations and the virtual hasn't affected that at all. If anything, it's made it more expeditious. And the only thing we run into sometimes is just document exchange. So that's really the only issue I've encountered. If anything, I've been more successful with virtual. I've learned to adapt to it, and other people have as well. So no one wants to sit and stare at their own face for 8 hours. So.
Well, is there anything in particular that you believe is vital to getting the parties to a place where settlement is possible in mediation? Either things that you really wish they would do or things you really wish they wouldn't do?
I think it's the anchoring, all right? Hey, we're going to start here, and then we're going to, it's my job to cool temperatures, right? Make sure people stay in their seats, if you will. I think there's just sometimes where people get upset with what the other side said, when I don't think in all the years I've been doing mediation, I've ever been in a mediation where someone goes, you finally caught us, we're a bunch of discriminators. That's not going to happen, or someone says, well, I made this whole story up. I just want to withdraw my charge because you caught me. I made this story up. So there's always going to be two different sides. And I think the expectation that somehow you're not going to be upset in some form or fashion by what they said during, say, a joint session or whatever, I think that's kind of ill-advised. Just come in, hear what they have to say, and then understand that you're here to resolve it. That's the whole point of it. Otherwise, why would you even mediate? I think that's really one of the main things, and maybe one of the only things. Otherwise, it's just come in and have an open mind, be prepared to work towards a resolution. I I think that answers your question.
Yes.
And you clearly have a style with the way you go through mediations, and perhaps that's a style that is agency-wide. Have you seen other regions operate in different ways?
Yes, I've been really lucky. You know, I've had great supervisors. Three in fact, because I had one in the St. Louis district. So I was in Kansas City, but that's part of the St. Louis district. She was great, and then I had one here, and he retired, and then a new one, and they're both amazing. So, but I will tell you, they have different styles, and so I think what options are available to us and how we can kind of adjust our style and what breadth we have. Probably a little bit of that comes with what is allowed from our supervisors. So what happens in Chicago may be different versus what happens in Florida or, LA or Alabama or whatever, So, you're going to see maybe some different things in different areas, but for the most part, it's standardized. EEOC settlement agreements are from headquarters. You press a button and they come up. That's what it is. So
You mentioned the joint session during the mediation, and I wanted to ask you a little bit about the joint session. So folks who have mediated before know that typically the mediation starts with a joint session with the parties in the room with the mediator, and then the parties will split and go into separate rooms while the mediator works with both parties. I have noticed a trend lately where there are people who are hesitant to engage in a joint session because they are fearful that this might set a tone that's not conciliatory at the start of mediation. Just interested in your observations on that. Have you seen that same thing? And what would you advise folks who are concerned about that when they come to mediate with you?
No, I agree with you. There are certain people who are very reticent to do a joint session and to do an opening statement. I think everyone, for us, or for me, I should say, in my style, again, 10 different mediators, 10 different styles, it's very important for me to do a joint session because in doing that, so it allows me to make sure everyone gets introduced. There's no disconnect on who's actually there, what their roles and job titles and things like that are. But secondarily, it allows me to use that time to make sure that I kind of set some ground rules, and that means going over our EEOC agreement to mediate and our confidentiality agreement, make sure there's no disconnect, especially in the world of Zoom and things like that. Nobody's recording or whatever, and make sure everyone's in agreement because they're all signing those documents. It can be a nasty thing if someone does that. So just little stuff like that, and I only do that for 3 to 5 minutes. But I always start with the plaintiff's side, and I want them to do a joint session, or I want them to do an opening statement, and they don't have to go long. I just want them to hit the high points. Why do you think your case or your charge has, something to it, right? And they may not have really gotten into those points too much. They may have just exchanged opening demands and counteroffers. And then if it's a pro se party, that's their day to speak directly to the company. And so it's very important. It's cathartic for them. And I don't think people realize that. But at the same time, and I remember there was an attorney, Eric was his name. I won't give you his last name, but he was really fun to work with. But he had this kind of, I call it the 8 Mile moment. I don't know if you ever saw that movie 8 Mile with Eminem.
Yes.
Yes.
But at the very end, he wins the rap battle. And why does he win the rap battle? Because he puts everything out there about him, right? And the guy can't come back, right? But the idea being in my head, right? That's why I call it the 8 Mile moment. It's like, here's our cards, and this is why we think we're going to do it. We're going to win the lawsuit, if you will, if you think you're only going to go file suit. But this is why we think we have a really great claim. And I think it's the same way for both sides, right? Here's why we think we have a good claim. And if the temperature rises, that's okay. What's my job? Lower the temperature. and I'm confident I can do it.
Right. That was my question. In that cathartic moment, as you described it, it seems that cathartic moment can become contentious really quickly. So what's your style in bringing the temperature down in a room like that?
Well, I just reiterate, if someone starts to interrupt, I'm like, we all agreed this wasn't going to happen. So if you got to put yourself on mute, then do it, whatever. But we're not going to do that. And if you do it again, then I'll put you on mute. I'm not afraid to step in. But in terms of professionals, most attorneys either know each other or understand the professionalism necessary to handle that. It's the clients that get upset. So later on, when we get into the breakout rooms, they know. So I'll talk to them and I'll cool them down. But I also use like prefacing statements like, you'll likely hear things that will upset you because they're different than what you believe. But use this time to just intake what you heard and understand risks moving forward. So I use things to kind of preface what's coming. And so...
Well, I know personally from having been in mediations with you, without divulging any confidential information, that you do a very good job of setting expectations in a realistic place at the beginning. And when people know what to expect, generally things like mediations tend to go better. And speaking of expectations, I know that many who know you rarely see you without your longtime friend and companion, Ida. And I wanted our audience to know that she was invited to come with you today, and that she unfortunately couldn't make it. But perhaps if you are willing to join us on future episodes, we would love to see, and I know our audience would love to see her.
She'll be here. She's at every mediation.
And let's make clear that Ida is a canine.
Ida is a canine.
She is my dog. So.
She is a canine.
Yeah.
So we would love to have you back to see and visit with her, to hear more great rap references, and to hear everything else you have to say about mediation at the EEOC. You're a wealth of knowledge. Thank you, Drew.
It's great to be here. I'm so glad.
Thank you for being here. Not once, but twice. We really appreciate it. We will see you next time on Work This Way.